Good morning. Did everyone have a good weekend? Welcome to the First District Court of Appeals. Today is Monday, July 15, and we have 5 cases on the docket this morning. 3 is scheduled to argue. The first case we have is case number C230628, Burheem versus Walmart, Inc. If the attorneys can please identify themselves and their readiness to proceed.
Good morning, Your Honor. Todd McIntosh for the appellant.
Thank you.
Good morning, Your Honor. Todd Harris for Walmart.
Thank you. The next case we have is C230558, Minges versus Brewington.
Brian Lee on behalf of the CSCA, ready to proceed.
Good to see you, Mr. Lee.
Robert Kelly.
Good to see you, Mr. Kelly. The next case we have has submitted on the briefs. It's case number C230569, Hamilton County Land Reutilization Corp. Versus John Klosterman. The fourth case we have is case C230432. This case is scheduled for argument, State of Ohio versus Chris Simpson.
Good morning, Your Honor. Sarah Nelson on behalf of Mr. Simpson.
Good morning.
Your Honor. Thank you. Ready to proceed.
Good morning. And the last case we have that has submitted on the briefs is case C230601, State of Ohio versus Nathaniel Gurton. All right, so with that, Attorney McIntosh, how are you doing?
Well,
If you can come onto the podium. Would you like to reserve time?
yes, I would. I'd like to reserve 5 minutes. If I
5 minutes, all right. You can start whenever you're ready.
Thank you, Your Honor. Well, in 30 years, I don't think I've ever come before this court or any other court with hat in hand talking about a 60B relief for excusable neglect. As I outlined in my brief, the burden was...
You can speak up. Just
Pardon me, the burden was exceptional. My father, who is also a lifelong practitioner here in Cincinnati, is now 89, has advancing dementia. That was developing. He lived alone. I was the sole caretaker of him, and at the same time, my sister-in-law, who has schizophrenia, had a florid break. I did 7 years as the magistrate for mental health here in Hamilton County, and I do not know why, but Christ Hospital chose to release her to our care without repair. And
it
so
sounds
I
like
had,
it was a very difficult situation.
it was extraordinary in its conduct. And you never know when you're in those things that you're under that pressure until something like this happens.
Understood.
But, we're not only here to review that. There are also other meritorious underpinnings to this case that would merit its return to the trial court. 60B has 5 different criteria. The first, I raised my error. The fifth is that there was actual service. And the one...
So you're
fact-
focused not on 60B, not 60A.
Correct.
Okay.
Right, 60B. And I briefed that at the trial court level. But 5 is the fact that there was actual service. That is an ironclad fact. It's not been argued.
Well, let's talk about the actual service, and this is where there was certified mail service to the store. Is that what you're
Correct.
talking about?
Correct.
So my question is, how do we know that that was on Walmart, Inc.?
So this is difficult. Walmart, Inc., or Walmart, if you go to the store, if you physically go to the store, it says Walmart. You buy anything
Sure.
here, it says Walmart. You look it up online, it says Walmart. Maybe a super center here or there, but it all is Walmart. Now, I didn't draft the complaint, Mr. Richards did, but if you were to sue Walmart, you're suing Walmart. And I would think that that service is obviously signed for him, it's in the record as well. Do we know it's on Walmart, Inc., only raised before your honors in the response to the appeal brief? So I think what's very important is through the whole trial court level, there was never any argument that Walmart was not a different entity from Walmart Stores East LP.
Well, who has the burden of identifying the defendant?
I think the plaintiff has a burden of drafting an appropriate complaint, but I also think that, as the Supreme Court has said, the caption of a complaint doesn't drive that complaint. It's the body of the complaint. And certainly under 15C, those things can be corrected. So under 3A and 15C, you can correct the name.
Well, but I think that the issue here is Walmart, and I'm sure other retailers like it, Like, they specifically structure their operations so that Walmart Inc. doesn't get served a complaint at a store and some, manager who has no idea what to do with that because that's not really their job, misplaces it or whatever, and then suddenly there's default judgments against Walmart. So that's like, I mean, that's just basic corporate structure. And if you're suing Walmart Inc. versus the store, the entity that ran that store, like, it's incumbent upon the plaintiff to figure out who's the proper defendant here.
I think to an extent, but what I'm also indicating is, in as much as, a plaintiff can only request service, it can't make the post office serve it any faster, or if that time edges this service, I can't make the post office go any faster. The rule doesn't say, that you have, it just says you have to serve it at their place of business. So whether or not a clerk or a manager or someone doesn't do it after that, that's still valid service. I think the thing that concerns me and surprised me the most is through all of this, the trial court never knew there was another entity. The Walmart Inc. did not come to the trial court and say, oh, you know what, we are not responsible to answer, they asked to dismiss the entire complaint as if they were the defendant.
Now, we're to view this under the lens of abuse of discretion.
Correct.
So how is this an abuse of discretion?
Well, Your Honor, I think that it goes beyond just an error. The court certainly didn't make an error. It decided, first it didn't take notice of the record, okay? So even Walmart Inc. argues that the court has the right and responsibility to take judicial notice. Under 201B, my having filed a notice of the service actually calls to the question the court's responsibility to take notice of the record. But it did not take any notice of the record when it determined in its original entry that that there was no service, because there was service, whether or not it was particular on a certain entity versus another secret entity that comes out later.
What's the exact language of that entry? I mean, could it be read that the court was saying that that proper service was not procured, as opposed to there was no steps towards service?
The court said that the defendant was served with the complaint on July 24, over 1 year since the complaint of the initial filing, and over 3 years since the incident causing alleged. As such, this case was never properly commenced, and the 2-year statute of limitations for an action bodily injury expired. There was no reference that she considered the record, and obviously couldn't have, because had she seen it, then things should have started falling into place, even under a 60B motion. When I put up the fact that there was an undeniable fact of service, she should have had a hearing to determine that. But again, all she's working with is the motion that says dismiss the complaint, we're Walmart. And yet they never brought that to her attention. I think that falls under 60B3 to some extent.
Yeah, let me ask you, Mr. McIntosh, I've taken a look at the record, and you suggesting that the court should have taken judicial notice of its own record?
Correct.
Okay, and it seems what brought everything to light, at least to a head, was the court's sua sponte notice of intent to dismiss due to lack of proper service on the defendants. It states it would be dismissed without prejudice.
Right.
All right, and I guess the defense attorney alertly thought, well, that sounds good to me. Why don't I file a motion to dismiss? Now, I will say, when I've read the motion to dismiss, it seems to focus mainly on the fact that there was not good service on the statutory agent within the statute of limitations, which I agree with. I agree with that because they were not served. The statutory agent was not served via certified mail. But what I see here is this. Looks like on 4/10/2023, service was perfected at the Ferguson Road address, which was within the statute of limitations. So all this does have a point. It seems to me that the court focused on the statutory agent and not so much its own docket, because had they looked, it seems to me they would have seen this return of service signed by somebody named Eric Manns. And in addition, isn't there a presumption that, a rebuttable presumption that service is good when you get a certified mail receipt back, like the one we have right here? All right. So I guess I was going to save this question for opposing counsel. Where was that presumption rebutted? I mean, anyway?
They did not rebut it. There was no, through the entire, if you look at all of the documents that were filed by the appellant in the trial court, not once did they discuss that service, or actually the really weird service that Mr. Richards requested of personal service on a corporation. They didn't even argue that one, but okay, that's not legitimate. This one is a legitimate service, and he never argued it was not. And I think it's because, of course, it was legitimate as to an entity that was misnamed in the complaint. I think also the court, 201, I think, says, as I recall it, says the court may take judicial notice. Of course, the nature of this motion requires it, but once I filed the notice of service in response to that, I said, oh, no, we have served it. That brought the court directly in line. I requested her to take judicial notice of what was already on the record. So I don't understand why the trial court simply, and the appellant, or appellee, simply ignored that service. That's what threw me the whole time. It has thrown me until I saw the reply brief, where all of a sudden this Walmart East LP comes into play, never identified in any way, shape, or form. And I don't disagree with you, Your Honor. I mean, it is, but if you are working on the case law, for example, of misnaming a personal plaintiff, misspelling a name, things like that, the court looks toward the rules, generally speaking, to get things on their merits, to get a decision on its merits. And this is something that simply, very well, if it had been brought up or even drawn to anyone's attention, could easily have been corrected under 15C. And so I think that it should go back, not only for the fact that the court did not take its own judicial notice, but she changed her opinion. She literally, when I filed my 60B, she didn't say I was wrong. She then denies my 60B under a local discretionary rule that I didn't answer the motion. While I did file a notice, which was a responsive pleading, she simply says I didn't answer, and so now I'm going to do it this way. So would that by deference mean that my motion should have been well taken? I think it does. Your Honors, I believe that under 60B1, to some extent B3 and B5, certainly there is reason for a 60B motion to be had. I think there is a meritorious meritorious claim and a defense to the motion to dismiss. I understand from my part, and I've never had to do this, but I distinctly apologize for my failure in being confused about my scheduling and this filing. And I hope the
Thank
court
you.
can see fit for that.
All right, thank you for your argument.
Your Honor. Mike Caligaris for Walmart, Inc. First and foremost, it is well-settled law in Ohio, and particularly in the First District, as it was under Mueller v. Hammond, that the neglect of a party's attorney is imputed to that party. It does not constitute excusable neglect. While I understand that plaintiff's appellant's second attorney may have had some personal issues going on, some scheduling errors, things like that, those do not constitute excusable neglect under 60B1, which is the only issue raised properly before this court.
Well, he says he got service on you.
As it relates to service, Judge Bergeron, the April of 2023 service date was served on a store, a local store that is not operated by Walmart, Inc. Had we had the opportunity to respond to that specific issue, we would have. However, there was no opposition to the motion to dismiss, so the issue never came up.
So did your motion to dismiss, and I read it a while back, so I don't have it right in front of me, but did your motion to dismiss say, we're Walmart, Inc., and Walmart, Inc. does not operate this store, and here's an affidavit that shows that we don't operate this store?
We did not. We did not have the opportunity to do so, Your Honor, but I believe that
I mean, you had the opportunity to do so. You're filing a motion to dismiss saying we weren't served.
And our motion to dismiss is based on the commencement under Rules Civil 3A as it relates to the trial court's finding in that notice of intent to dismiss that service was not proper. By the time that we were brought in and counsel was retained, myself included, by July of 2023, we checked the immediate proceedings in the case, find that service has not been raised as being proper by the trial court.
But at that juncture, was it that service was not proper, or was that service was not had?
Service was not had under the notice of intent to dismiss. There was some mention in that filing that the proper entity has not been served properly through the civil rules, and that a case management conference, no party attorney appeared for the plaintiff in the trial court, and so therefore the trial court set out a date where proper service had to be effected. However, the Civil 3A or Civil Rule 3A commencement rule cannot be told, it cannot be extended. It is a hard rule under Ohio law, and the 1 year
I want to
date.
get back to the service was not had. So if the trial court is moving forward under the understanding that service was not had, and there was some form of service, and you chose not to address it at that juncture, you know, you are an officer of the court, okay?
Correct,
So-
Judge Ives.
So what the trial court is moving forward on is different than what the record of proceedings is reflecting.
I would understand that to, I guess from our understanding, the trial court's notice of intent to dismiss was saying that the certified agent for Walmart Inc., or the parent company for Walmart, was not properly served. As it relates to service being on the local store, that would, again, had the issue come up and in opposition to the motion to dismiss, we would have raised the particular issue that the usual place of business under 4.2 would not have been the local store, but the principal address of Walmart Inc. or the certified agent. However, no opposition came for 50-plus days, and respectfully, the second attorney in line for Ms. Berhane had not filed a notice of appearance, and so our service of that motion was on the original attorney, the only one on
What
the
effect
docket.
does that lack to respond have before us?
Well, that relates to the issues that are properly raised before this court. It's waiver. And the public steel that's in our brief, the inability to raise an issue in the appellate court is well-founded law in Ohio when the trial court proceedings don't reflect any type of addressment by the parties.
Well, but I mean, maybe it was inartfully captioned, the notice of service, but them filing something that says, we served you, is, at least can be viewed as a response to what you're filing, which is a motion to dismiss saying we haven't been served.
And that's a great point, Judge Berger, and I think that the notice of service that came after our motion to dismiss, which was about a week or two after our motion to dismiss was filed, actually conceded that service was properly effected in July of 2023, the third attempt, which was through the corporate agent. And it states, subscribing counsel requested on July 21, 2023, that service be reissued to the defendant's statutory agent, omitting the address. The Hamilton County Clerk of Court docket indicates that service was returned successfully on July 31st, 2023. And so as it relates to judicial admission, as we outlined in our brief, from our standpoint, that was also a concession or an admission of the party that that's when service was perfected. And that goes back to Rule 3A commencement, and that would be outside the 1 year time frame, and statute of limitations would be told, or it would be expired at that point, excuse me. However, as it relates to the trial court proceedings, though there was no opposition to the motion to dismiss, a motion for leave or a motion for relief was filed under 60B and 60B. However, a close reading of that motion would show that it was only 60B1 that was raised as the ground for relief. And again, that goes back to Mueller v. Hammond, that this does not constitute excusable neglect. However, had plaintiff appellant's attorney raised B3 or B4 or B5, that'd be a different discussion. However, we're constrained again under the public steel precedent that the issues raised before this court is only B1, and that's excusable neglect. And B3, B4, and B5 do address voidable or void judgments. And frankly, there's even case law out there that 60B doesn't apply to a service judgment. It would be void just as under the service rules and due process. However, those other provisions or grounds under 60B were not raised, and so the only addressment made by Walmart Inc. in the trial court was 260B1, and there's ample case law that excusable neglect has not been shown, which is what the trial court's ultimate ruling on the motion for.
Is it that excusable neglect has not been shown, or that even if there is excusable neglect, that can't operate to extend the deadline?
That's a great question. I think that the trial court's decision was that excusable neglect was not shown. in terms of the commencement rule, I think the case law in Ohio states that commencement cannot be extended at all, period, and that's under Hewitt and Moore.
Let me ask you this, sir. I'll follow up. I asked Mr. McIntosh the same question. He looks like he filed on August 21st, 2023, notice of service on defendant, where he indicates that defendant was served on April 17th, 2023, within the statute of limitations. And further asked Mr. McIntosh about what evidence was there to rebut the rebuttable presumption that once the court gets that gets the return receipt back signed by purportedly somebody at Walmart on Ferguson Avenue, what evidence was presented by Walmart to rebut that presumption?
So again, when Walmart was served a third time and retained counsel and filed
I'm
a motion to dismiss.
talking about him saying that they were absolutely served on April 17th, 2023. How did you rebut that?
So we did not rebut that in terms of a motion practice. The notice of service on defendant, from our standpoint, did not address the motion to dismiss. It was more in our mind, from trying to understand the immediate proceedings prior to our involvement, was addressing the trial court's prior notice of intent to dismiss.
But when you looked at that notice of intent to dismiss, didn't you see this service of notice on defendant? I mean, it's filed. It's in the court records. I'm not saying you did anything wrong. I'm just saying that why did you not respond to that specifically?
Yep, certainly. And I think that, again, that came after our motion to dismiss was filed. And then
You file an amended motion to dismiss.
And we did not do that, and we waited for an opposition to come. A case management conference was held months later, and there was no appearance by the party for plaintiff appellant. And so that's at the time when the dismissal came.
Yeah, and that kind of goes back to my question in a way, because if the record is incongruent to the motion, as an officer of the court,
Certainly.
what is your responsibility at that time?
Certainly, Judge Dias. And I think that from our standpoint, relying on the trial court's finding that service was not proper from the notice of intent to dismiss at the time that I was retained and filed a motion to dismiss, followed by the notice of service on defendant by plaintiff appellant, which outlines that July 21st, 2023 was when service was perfected. From our standpoint, that's when we confirmed that, from our view, that the commencement was not met within 1 year. From the April timeframe, though there could have been addressment as to the proper legal operating entity of the store, the usual place of business for a parent company that's headquartered in Arkansas, we just don't find it to be in line with Rule 4.2. And if that had been raised in an opposition, we would have addressed it. But at the time that we filed our motion to dismiss, again, the trial court's record as to the service on Walmart, Inc. Was clear to us. And so that's what we ruled or raised our motion on, was the commencement issue. When an opposition did not come and the motion for relief was raised in November of 2023, again, that issue was not particularly raised for the trial court's decision even. And again, so it's B1.
So I want to make sure I understand something, okay? So at the juncture of the motion to dismiss, it was all about whether service had been had, not whether there was proper service. Is that correct? And
Right.
so this certification of service was not discussed, was not acknowledged. Is that right?
Yes, Your Honor.
Okay, because I think that then the argument coming from the appellant is that it was an abuse of discretion at that juncture to enter a decision that was inconsistent, and there wasn't any evidence in the record at that point that service was not proper. That, like what you're sharing with us now, that this was not Walmart Inc., that this was another entity. So none of that was before the court. What was before the court was the certification of service.
And it goes to that rebuttable presumption, and I believe that though it was not raised by Walmart Inc., it was not raised in opposition by a plaintiff appellant either to address that issue. But as it relates to excusable neglect and the opportunity to raise those issues with the court, again, those weren't raised by plaintiff appellant at the time after the decision was made by the trial court, and it's not properly before this court today.
I don't know if there's any other questions. Is there anything further that you'd like to dismiss?
One additional point would be, as in terms of judicial notice and asking the court for a hearing, that is a requirement. The court may take judicial notice of its own docket, and it may consider a party's request for judicial notice about service in particular. However, that needs to be done under Rule 201 through a request for a hearing that was never made.
Yeah, but I'll say I've had these hearings before, and I always felt that it was incumbent upon the defendant to bring forward something, whether affidavit or something saying this, we don't know who this Eric Manns person is. It was the wrong store. It's incorrect corporation, something like that. So it's my understanding of the law that once you have a certified mail receipt back, you enjoy a presumption that needs to be rebutted. And is there any way you can convince us that it was rebutted, or at least convince me?
And I think that goes back to the usual place of business under Rule 4.2. I understand that there's a presumption that perhaps certified mail in a local store would be a rebuttable presumption, but large view, I would say that the parent company, Walmart Inc., not operating the store itself in Ohio, is in itself axiomatic that it would be not proper service. Thank you, Your Honors.
Thank you. Thank you for your argument this morning.
Thank you again. There's a lot of things wrong with that. First, the neglect is imputed to the party. I'm not saying in any way, shape, or form that I'm not responsible for my error in this, and that I'm not arguing that it's imputed. I'm also arguing that my error the excuse for my error should also be imparted to the party. 60B1 was not the only issue raised in my 60B1
And
motion.
that's really my main question. I think central to the argument from the appellee is that the only thing that should be properly before us is 60B1.
If you refer to my 60B motion, I talk about 60B1. I also talk about the failure of service and the failure of judicial notice, which would be 60B5. I couldn't have argued 60B3 because I didn't know about it until after the appellee filed its brief that there was another entity there. The whole time.
Wait, I'm sorry, you said 60B3?
60B1 and 5 are what I raised below. I did not know about this difficulty with knowing the name and not answering, and I have some more argument about that. You know, they say that I didn't argue that there was another entity, but we didn't know that. All of this was raised, service was raised in my 60B
Well, then
motion.
let me ask you this. If the first time that it's raised that Walmart Inc. is not Walmart, the store that was served, or that the complaint was provided to avoid the term service. If that's being raised in the reply brief, how can we even consider it?
Understood. That's sort of the 60B3 thing that's coming up, is because down below, they never mentioned that.
That's my point. If it
Right,
was never
so-
mentioned below, then how can we consider
If you take that out of the equation, then
Inc.
Walmart was effectively served by street service. It's there, and he doesn't argue it. His reply brief admits there was service. I mean, he doesn't say anything different. I don't understand. You know, the difficulty, he's wrong. The court did not determine in its notice to dismiss that service was improper, wasn't effectuated or anything. It simply said service was not made. If you look at the court's order, the court does not say anything about the merits of service.
This is what I would like for you to do. It would be very helpful. You know, looking at the record as the record was with the trial court, okay? Looking at your arguments below and your argument, you know, and then carrying them over into the appeal. Can you please share with us how this is, you know, how this is reversible error under 60B1 or 60B5?
Certainly. 60B1, Your Honor, this is not your average neglect. I didn't just, you know, miss a date. I mean, I misscheduled something, but I had onerous burdens upon me, and I'm asking for that simply.
Well, no, I appreciate that, and I
Sure.
empathize with that from my own personal experience. But I guess my question is, going back to the question I asked your opposing counsel, like, is this a situation where excusable neglect, assuming it exists, can operate to extend the deadline? Because this is,
No, it's not extending the deadline. It's that the court decided that in her second, or her her entry denying my 60B motion, she denied it because I didn't file a reply. Only because I didn't file a reply, not because there was a missed case management service. There were 9 case management service, all of them, but the one was missed and the other one was the hearing that I didn't know, well, I assumed wasn't necessary. I'm not talking about extending the timeline for the statutory agent. Okay, I believe service is proper and complete under the rule when you get street service.
So is your excusable neglect a failure to respond and to bring to the trial court's attention that there was that there was service with regard to that store?
No, because I did. I did file a notice beyond simply relying on the record, which the service existed before the
So
appellate got involved.
Help me understand what the
secondary.
excusable neglect is. What's the act?
Well, the judge says I didn't file a response. I disagree with her, but I didn't file something titled response to motion to dismiss. I had already filed the notice of service, which is a response, and again, I go back to the fact that
So how
captions
is it excusable neglect, failure to respond, if in some ways it's inconsequential whether you had responded or not?
I suppose that I would first stand on the fact that my notice of service was a response. Alternatively, if anyone would believe that was not an actual response, I believe that not filing things further would be my excusable neglect. But on top of it, the B5, the court's failure to take notice, is also significant because they argue that the court should have taken notice. The nature of the motion requires her to take notice. And yet she skips over the operative part of the record, 2 pieces of it, to find there wasn't service. And then when she's directed to it on the 60B and they reply, they still don't reply. Even though that issue is specifically raised, they still don't reply to the 60B motion to say, hey, we're a different entity. They still say, well.
So you're out of time. I'm going to give you like no more than a minute. If you can please express to us how 60B5 applies.
So that's any other meritorious reason for return.
I'm talking about with the
In
record.
simple fact, there was service. And that's why this case should not be dismissed. Should the court see that Walmart Inc. is not the right party, I would believe the court should remand it and allow me to change the name of the defendant. But as the court looks to the purposes of the motion, or I'm sorry, the body of the complaint, I certainly aver it, and it's clear that that's what happened. I don't, if it's Walmart versus Walmart East LP, I hit the name, I just didn't hit the whole thing.
Thank you.
Thank you.
All right. Thank you both for your arguments this morning. We will take the matter under submission, issue a timely decision. I wish you both a wonderful afternoon. Okay? Thank you.
Thanks so much.
Good morning. Good morning. Okay, so this is Minges versus Brewington. Attorney Cowley, how are you doing? Good. Would you like to reserve time?
3 minutes, Your Honor.
Okay, you can start whenever you're ready.
Your Honor, this is Mr. Brewington's appeal to this court on the registration of a foreign support order. And largely, this deals with a number of documents that were submitted to the trial court that originated out of the Indiana courts involving his divorce, subsequent prosecution in the state of Indiana, and the proceedings that occurred and are still ongoing at the present time in terms of him being able to get the documents that he needs from the state of Indiana, which have been denied him. The bottom line of the situation is that the state of Indiana sent over the child support order to the state of Ohio to have it registered in the state of Ohio. And one of the bases for not admitting
And although
it.
there were multiple things before the court in Indiana, really before us is the registration of the child support order from Indiana into Ohio.
You are correct, Your Honor.
Right, because you're not trying to collaterally attack the Indiana.
Absolutely not.
Because as I was reading your brief, it sounded like a collateral attack on the judgment and the factual and procedural backdrop.
And it's not a collateral. It's not a collateral attack that this court could do anything about to change the Indiana decisions. What this court can do is investigate those decisions to determine if that foreign child support order should be registered in the state of Ohio or if it is permeated by fraud. That is provided in the registration of a foreign decree by the statute in this matter.
Now, the record is quite interesting in this case because there were 2 entries by the trial court,
That's correct.
okay? And you appealed as to the September entry.
That is correct, Your Honor.
So there was I believe that there was an order that was received last week with regard to trying to address finality and which order's before us and do we have a final appealable order and all.
Your Honor, I looked at that and quite honestly, it was kind of perplexing in a way because that's the first time I've ever been confronted with that. But I think the operative order is the final order that was issued by the judge because that is consistent with what the judge represented at the hearing on the objections. So it wasn't like she pulled a rabbit out of somewhere. It's like she made that statement on the record, and it's within the last 2 pages of the transcript, that if she needed another transcript, she would request the transcript. And quite frankly, Your Honor.
So when she put on the first entry that no transcript has been provided, was that inaccurate?
Absolutely.
Okay.
Absolutely. It was inaccurate based upon her discussion at the end of the hearing. That's why there's a transcript that specifically addresses that issue. That's what occurred. It's not like she made this decision and then, well, I'm going to go back and change it to extend appeal rights or anything else. She, in other words, she articulated exactly what she said in the second
I want
decision.
to make sure I understand your response. Are you saying that when the August 29th entry was put on by the trial court, that at that juncture, the Indiana transcripts were before the trial court?
The Indiana transcripts, I believe that all the exhibits were before the trial court at that time. And I brought them down. They're sitting there in that white binder, Your Honor. And I went back through the transcript to look at all those items. Those were all before the magistrate at the time of the hearing. There was very little testimony in this case because it was essentially driven by initially a memorandum and then the documents. And it's really hard to explain where. And the only reason I know this is because I was tangentially involved in the Indiana criminal proceeding at one point in time. So I knew what was going on with that proceeding and also with the divorce proceeding. And essentially, I was trying to lay out to the magistrate that this is how this proceeding went in the state of Indiana. And one of the big issues in the state of Indiana is when this judge made the decision on the child support order, he would not release the custody evaluator's report to Mr. Brewington, which directly affected his parenting time or his ability to litigate that. And if he had litigated it and proved that the findings by the custody evaluator were incorrect, he probably would not have had a child support order. Because essentially what the trial court did is they stripped him of all his parenting rights without providing him with the opportunity to review the custody evaluator's report to the judge. Not only did the judge deny him that right, but when Mr. Brewington was before that judge, and when that judge was
See,
writing,
now all this is sounding like a collateral attack. You're saying that all of these, you're asking us to second guess what was happening in Indiana.
I'm not asking you to second guess, Your Honor, because if you look at the exhibits, all this information which I'm relating to you is all in the record in Indiana. And what happened is, whether the Indiana courts will acknowledge what occurred, which is, quite frankly, so clear it's unbelievable based on these documents, which I find difficult to believe that could occur. But on August the 1st, when the criminal investigation was started against Mr. Brewington, his divorce judge was a primary witness on the criminal case, stayed on his divorce case for a year after, and wrote the decision on his divorce after he knew that there was a criminal investigation.
Was there a
going on.
grievance filed with the Indiana Supreme Court with regard to the trial judge in Indiana?
There wasn't a grievance filed, Your Honor, and the reason why is once the decision came out, they immediately proceeded against Mr. Brewington and indicted him over in Indiana. So once they indicted him, they put him on a $500,000 bond. He could not get out of jail. He could not make the bond. And he had no access to legal counsel at that time on his criminal case. And what happened was they essentially tied him up for the next 2.5 years.
So what do we do with a well-settled law that this tribunal does not have authority over grievances with regard to judges?
I'm not asking you to deal with that issue. I'm asking you specifically to deal with this issue, which is in 3115.
Well, but your issue presented for review under the first time of error says that the judge was biased, had a conflict of interest, and failed to follow the Indiana canons of judicial conduct. So are you asking us to make those findings that?
No.
Okay.
In other words, what I'm asking you to do, if you look at the statute, 3115-607A2, if it states, if the foreign child support order was obtained by fraud, if Mr. Brewington, not based on any fraud that occurred in the state of Ohio or on behalf of any judge in the state of Ohio, because I've never encountered anything like this in 43 years of practice, but if he can prove that what occurred in the state of Indiana violated the canons of ethics, I'm not saying you have to set any order aside.
So where is that legal argument, the statutory argument that you're saying in your first assignment of error?
The fraud argument, Your Honor?
Yes.
That's in my brief, Your Honor. And I guess what I laid out for you is exactly what occurred in these.
Well, you just cited a statute to me, and I'm looking at your brief, and
I'm
at least I'm looking in the argument section. I'm not seeing that statute.
I'm looking for it, Your Honor. And
So what I'm just trying to understand is what that statute provides and how it applies in this context.
well, it applies because it says a party contesting the validity or enforcement of a registered support order or seeking to vacate the registration has the burden of proving one or more of the following defenses. One of the defenses would be the order was obtained by fraud. And I think if you look at the brief, in this...
But doesn't that, when we talk about fraud, at least in like the 60B context, we're talking about fraud of the opposing party committed on the tribunal, not fraud by the court itself. And I'm just wondering, like, does that apply in this context? Because my understanding is your critique is on like what the judge and other judicial actors were doing, right? Or am I misunderstanding?
Well, I think you're misunderstanding to a certain extent, because I'm saying not only the judicial officer at that time, but also opposing counsel on Mr. Brewington's termination of his marriage proceeding. They call it a dissolution, but it was actually in the nature of a divorce in Ohio. The opposing counsel even went to the judge without notice to Mr. Brewington concerning his postings on a website complaining about not being able to get the custody evaluator's report. That's essentially what occurred. That initial contact by that opposing party's attorney then prompted the judge to request a criminal investigation. You have to understand that Dearborn County is a lot smaller county than Hamilton County. So what occurred at that point in time, the prosecutor picked it up and went with it. The judge has acknowledged in the record of the exhibits and the documents that he knew about it before he wrote his decision. And as it cascades down from there, Mr. Brewington was promised very different information from the state of Indiana courts that he has been unable to get at any time. He can't even go over to Indiana, or he risks being prosecuted. I can't go to Indiana because they were trying to get me to sign a document at one time to get information from Dearborn County, and I said, I'm not signing it, because as soon as I sign it, they will in turn say, well, you're practicing law. I had to actually get admitted to federal court in Indianapolis to be able to go to the jail to see Mr. Brewington. Mr. Brewington.
Understood. So your time has lapsed. I want to make sure that there aren't any other questions from the panel. All right, thank you.
Okay.
Good morning.
Good morning, Your Honors. May it please the court. I was a little confused when I got here because there are so many people in the courtroom. And if I didn't know
they came to watch you.
there were going to be back-to-back Civil Rule 60 arguments, I'm now surprised that they're not media present. This is pretty exciting.
But we have, there's some students here from AJC's Simon Lazarus Award. There's also a couple of interns that I've been working with. There's also 2 community leaders that are here. So we have a very mixed group that's being hosted this morning, yes.
It's very exciting.
Including a young man who came from Canada to shadow me in the next couple of weeks. So.
And he'll be able to tell everybody back home about
So we've got
Civil Rule
all kinds
60.
of, folks here. And so, it's certainly interesting to see you on this side of the podium.
I believe that my brief has thoroughly addressed what my arguments would be on the merits. We submitted, in addition, a relatively substantial supplemental argument on the issue of jurisdiction. And as an alum, I kind of want to apologize for not having spotted this issue before it was pointed out to me by the court.
It was unusual. I don't know that it was super easy to spot. I mean, it was sort of unusual.
That's fair.
And, I think what also makes it unusual is that there was a mild difference between the two entries. Also, the record, as Attorney Kelly had referred to, reflects that the trial court had said, hey, if there's any transcripts of proceedings that are required, I will let you know.
Sure.
So I'm going to start with just sort of like a question of the record.
Okay.
At that juncture, when the August 29th entry was entered by the trial court,
Yes, Your Honor.
was the transcripts of proceedings before the court at that moment?
No, well, let me be clear about what we're talking about. The transcripts of the hearings before the magistrate. Is that what you mean?
Well, I guess, how about what were the was
Well,
Indiana there? Was
the transcripts of the hearings before the magistrate, which would have included, among other things, the magistrate's determination on the admission or exclusion of all the exhibits, were not before the trial court. Those transcripts, along with the transcripts with the objection hearings, were all filed after the notice of appeal.
Okay.
Which is why, if you look
So
at
the
this-
Indiana record was before the trial court, but not the transcript proceedings from the
Correct, Your
magistrate?
Well, wait, let me stop you there, because you said they were filed after the notice of appeal, but that would be after the trial court corrected its order
Correct,
to eliminate the sentence that says no transcripts.
correct.
So are you saying the trial court, was wrong about there not being transcripts? About there being transcripts?
Well, it's kind of hard to make that jump, because the first entry, the August entry, said that there had been no transcripts of the magistrate's decision filed, and that was correct. The second entry removed that language, but didn't say, yeah, we've got transcripts. It just removed the language. It didn't make the fact that there weren't transcripts.
Well, but then if that's the case, I mean, your opposing counsel argues that this is essentially 60A, a correction of a clerical error.
Right.
And I don't know, that kind of sounds clerical to me.
It is clerical, but also the issue with that is, and I've cited this in my response brief, or the supplemental brief, 60A corrections relate back.
Right,
to
it
the
should have
original
been
decision.
non-pro-tunc at that point.
Right. And, the distinction that's made in appellant supplemental, but that there's a difference between Civil Rule 60A and non-pro-tunc. Civil Rule 68 is non-pro-tunc. That's how you correct clerical errors. And that's why, if you look at, brought it up here, Civil Rule 60, the language in Civil Rule 60 contemplates that in 60A, the procedure to correct a clerical mistake does not generate a separate entry. It corrects the original entry.
Okay.
And in specific,
So
it
here,
says.
so here's my question,
Yes,
because
sir.
I understood, okay? Here's my question, is I've been thinking about this and like mulling it over and doing somersaults in my brain, and, okay? It's fascinating to me that the trial court said, I will let you know if there's transcripts that are needed. The void was the transcripts of proceedings from the magistrate's hearings, right? We're at objections. As a matter of law, you can say transcripts are needed
Yes,
when you
Your Honor.
file objections. Yet the trial court is telling counsel, I will let you know where the transcripts are needed, right?
Right.
And then an entry is put in saying no transcripts, and then another entry is saying there was transcripts. Going back to finality, it seems that that would weigh towards that second entry was the final appealable order, because of the trial court's own error in making a statement of law that was completely not proper.
Well, I think I would answer that respectfully. I would just have to disagree slightly with the characterization of what the trial court said. What the trial court said was that if I need the transcripts, I will let you know. and then did the entry that said, the transcripts weren't provided. Removing that language in the second entry doesn't change the substance. The proper procedure in this case would have been to file a notice of appeal of that first entry, which was final, while at the same time filing a 60B motion. Both of those arguments would have been, I was told that I would get an opportunity to provide a transcript if it was needed, but the entry went on and it said I didn't file the transcripts.
Well, but
that
what
would have been
about-
the proper approach.
Well, right, but like if a trial court issues a subsequent entry, as it did in this case, and let's just assume for the sake of argument that that was totally improper, shouldn't have happened. From my practice vantage point, a trial court issues an entry, and even if I say maybe that entry's improper, like I need to file an appeal, and so I see an entry that looks really final, so I file an appeal from that entry, and like I'm thinking about it from the reliance perspective on counsel who's faced with these entries. And so help me out, like why is that an improper way of looking at it?
Well, because the August entry goes on and it says what it says, but then nothing else happens.
Well, but like I'm the lawyer, I see the August entry, I'm like, okay, I need to get my notice of appeal together. And so I'm like working on my notice of appeal, I'm like, I've got 30 days, and then all of a sudden the September entry comes on, and I'm like, whoa, what is this? Where did this come from? Well, I guess I have another 30 days now, right? Like, I mean, it's not as if there was anything the lawyer did or didn't do that precipitated that September entry. It just came from the sky. But now, as a lawyer, I'm seeing this September entry, and I say, I need to take an appeal from it.
You appeal both. I mean, that would be my answer.
Would that have fixed it
Yeah.
if the notice of appeal said, I'm appealing both the September and the August?
If it was timely as to the August appeal, then yes, that would have fixed it.
But you're saying is once it's past 30 days from the August, that time.
Right. And because the way corrected entries seem to work from my reading of the jurisprudence is there's one of two possibilities. Either the entry that's being changed, whether we're saying corrected, amended, or to fix a mistake, if the entry that's being changed does not change anything substantively as to the parties, then it relates back to the original entry. On the other hand, if was what we seem to be arguing, that the second entry somehow made a substantive change, then the question which the court asked us to brief was, did the trial court have the jurisdiction to enter that supplemental entry once it had issued a final decision? And the case law, which I cited in my supplemental brief, is very clear that the trial court lost jurisdiction to make other entries once there's a final entry, absent 60B. And 60B says at the very end, the procedure for obtaining any relief from a judgment shall be by motion as prescribed in these rules. So those are the two options. Either it didn't make a substantive change and it relates back, or it made a substantive change that none of the parties asked for, and the trial court lacked jurisdiction to make the second entry. Under either scenario.
So your position is that it cannot be done sua sponte if it is a substantive
Correct.
change?
Correct. And even non-pro, that I remember, I read one case, and I didn't include it in my brief, and I can't remember the site. It was a case.
Because really,
where-
my question in essence is whether, in light of the fact that the trial court said that no transcripts were required, and then an entry is put in afterwards saying no transcripts provided, whether the removal of that entry really becomes a substantive change.
I'm sorry, I didn't hear the last part of your question.
Whether the removal of that line, that no transcripts were provided, becomes a substantive change in light of the record reflecting that the trial court had stated that no transcripts were needed, despite the fact that we are at the juncture of objections.
I would say that the removal of the language, our position would be, is insufficient to show that the trial court is excusing the failure to file the transcripts. Because we had argued in the objections that the transcript hadn't been filed. We raised that issue before the judge. So I would argue if the trial court had said something in addition to just removing the language that said, I had indicated, the court had indicated that the lack of transcripts would not be considered. And we're amending the entry to reflect that determination. But just simply removing the language without being asked.
I understand. Attorney Lee, can you, do you recall when you said, okay, so it wasn't until after filing of the notice of appeal that the transcripts were obtained, is that right?
I think it was, I don't think I have I think it was in
But that the transcripts became part of the record, I should say.
January 22nd of this year.
Okay. Thank you.
Okay.
So you have about 2 minutes left.
I'm sorry.
You have about 2 minutes.
Okay,
left.
thank you.
Okay?
I believe that we've covered everything. I did want to speak to the point, Judge Bergeron, you had raised earlier, the issue about, I think this is a collateral attack. I really do. And the reason I believe that, among other things, is if you read appellate's merit brief, the argument, which is like the last 5 pages, the word fraud isn't even in that section of the brief. It's not argued at all. The judicial conduct, all those things were argued, but the fraud was never argued in the merit brief. The language of the entire brief is a collateral attack. Now, we can frame it in terms of, well, we're only asking that the court not, tell the trial court not to register the order. But none of the statutory factors are argued in the brief. And we would argue that, based upon that, the appellant's not met the burden. But more significantly, the notice of appeal was not timely filed, and the matter should be dismissed. Thank you.
Thank you.
Your Honors, I would just state that when you go and you look at this transcript, you'll see in the transcript, it was specifically requested of the judge the ability for leave to file the transcripts in this matter. And essentially, if you read the transcripts, there is so little testimony in those transcripts, and it's largely directed to exhibits or documents admitted by the magistrate at the time of the hearing. But the bottom line of the situation, there is no way that you can outline for the court a basis for fraud unless you put in the factual history of this case, which lets the reader arrive at the decision of how does something like this happen? How does something like this happen with judges or whatever? They can sit there and say this is a collateral attack as much as they want to say it. But the bottom line of the situation is we're dealing with an Ohio law that gives him, Mr. Brewington, the reason to contest this on the basis of fraud. You have the information that categorically establishes it. And although this court's not a reviewing panel for judges, I can honestly say that if you ran into a decision where a judge sat in on a case, you're not disciplining the judge, but you're making a decision that there is no way that you can be a prosecuting witness on a case and at the same time be making a decision on that case. I mean, I don't see how you do it, but that's essentially what the issue is. And I know that CSEA, when they go through this situation and you read the transcript, they look at this like it's a perfunctory task. Got the foreign decree here, that's all we're worried about, give it full faith and credit, and that's it. Ignore the statute, ignore everything else. Don't want to hear about what happened in the originating court or anything else. As long as we've got the order, just enforce it. That's it.
So specifically, who committed fraud here?
Who committed fraud? Well, you could start with Judge Humphreys over in Indiana. You could start with the custody evaluator, because if you look at the custody evaluator, they actually filed a criminal charge against Mr. Brewington in Hamilton County. And I represented him on that, subpoenaed the custody evaluation file, and they dismissed the charge. But you could start with Humphrey, then you could go to the custody evaluator, then you could go to the process in Indiana in terms of the prosecutor over there. You could even go so far as to include the Dearborn County Sheriff in the process. You could go to the next judge who presided over his criminal trial, who appointed him a public defender who met with him for a total of 45 minutes. 45 minutes for a 3-day trial. For a 3-day trial. And it's in the brief that he requested new counsel, and they made him proceed with that attorney who only had met with him for approximately 45 minutes on a criminal trial, which then ended up in him being placed in jail for 2.5 years. 2.5 years on his postings on the internet. And during that period of time, he had no contact, no counsel, no nothing at that point in time. Most of the documents that you'll see in the exhibits were generated by Mr. Brewington as a result of his independent research. But that's what you're looking at in this case in terms of what transpired and what occurred and what happened. And if you believe that, as the CSEA does, we're just here to rubber stamp this and not look behind it, your decision's pretty easy.
Thank you, Attorney.
Thank you.
I just want to make sure, any other questions from panel? All right, thank you. Thank you both for your arguments this morning. We'll take the matter under submission, issue a timely decision. Have a wonderful afternoon and a great week as well. Good morning. This is State of Ohio versus Chris Simpson. Good morning, Attorney Nelson. How are you?
Fine, how are you?
Good, good. I hope you had a good weekend. Although it was quite warm, wasn't it? Yeah, it was. How much time would you like to reserve?
3 minutes rebuttal, please.
All right, you can start whenever you're ready.
Good morning again, Your Honors. May it please the Court. Good morning, opposing counsel. Sarah Nelson on behalf of Mr. Simpson. This case concerns whether the affidavit in support of the search warrant for Mr. Simpson's storage unit was supported by sufficient facts to demonstrate probable cause. In order to find probable cause, there must be an evidentiary link between the alleged criminal activity and the place sought to be searched. That evidentiary link or that nexus is missing in this case. Police sought to search the storage unit for evidence of drug trafficking without any evidence connecting the storage unit to that specific crime. This case begins when Mr. Simpson was stopped by Courtroom police for a traffic violation, and in the midst of executing that traffic stop, they found drugs in his vehicle.
So they found drugs in his vehicle, and then he offers to cooperate in some form or fashion to help identify other participants in drug trafficking, right?
Correct.
And so they've got that background. then he's on the phone talking to, I guess, his girlfriend and sister or whoever, and says, hurry up and get to the storage unit. My stuff's in there, like, it's in a safe, here's how to get the key. And obviously, he doesn't say the drugs are in there, but he also doesn't say, like, I left my keys to the car in that, or something like that, something benign. So with the backdrop that he is involved by his own admission in some sort of drug trafficking enterprise, is that call sufficient, identifying a specific thing in the storage unit and not giving a kind of benign explanation for it?
I don't think that it supports I don't think it's sufficient to support a probable cause that drug trafficking evidence would be located in the storage unit. Because all it really tells us in this case is that Mr. Simpson has a connection to that storage unit. Every other fact that we have learned in this case, from the traffic stop to his post-arrest interview, really only relates to that traffic stop. The admission to the evidence that he was caught with, the acknowledgement that the naming of the two suppliers, and the fact that he was going to distribute the drugs that he was caught with, again, all relates to that one incident that he was already stopped for and was being prosecuted for. The police can't bootstrap that case to a completely different area and say further evidence is going to be found there without more. And why I say that in this case is because, like you said in the call, he doesn't say anything more, like, I have drugs in that safe, because he directed them to a safe. So we could be dealing with something benign like bond money. A person could have a storage unit for a number of reasons, but there's nothing in this case to give police anything more than suspicion of additional activity at that unit.
But I mean, we've had a bunch of cases over the last year that have involved situations where maybe it's someone's residence, and we've tried to draw a distinction between evidence of drug activity going on in connection to the residence.
Yes.
In other words, like, I'm doing deals on the street and then I'm walking back into the house, or I'm traveling between two locations. And I think generally what we've said is, if there is indication that the defendant is engaging in drug activity and is using that location in connection with that, and we don't know for sure, right? Like, it's probable cause, that's okay. I think where we've drawn the line in some cases, it's when there is absolutely no evidence connecting that individual with the place to be searched, that we've said that's insufficient. So to me, this is like almost in between those two, because it's not as if he's physically going there, but he has admitted that he has ownership of this unit. And given his drug activity, like, is it reasonable to assume, I know it's assuming, but is it reasonable to assume that there might be some connection there?
Okay, I understand what you're getting at, and I
Yeah.
believe that this case is quite analogous to recent precedent by this court, where there is no connection of drug activity to the storage unit.
Now, is that case law with regard to an affidavit for a search warrant, or is that case law with regard to probable cause on site for the search, which is very different level of probable cause and review for us?
I believe the Johnson case was an affidavit case, where the police sought an affidavit to search the apartment after reviewing the defendant Johnson engaging in drug sales out of his car, the car going to and from this apartment in between sales, the police connecting the defendant to that apartment, but no link that drug trafficking activities were occurring within the apartment or originating in the apartment and taking them to the car and beyond. If I'm misremembering the affidavit aspect of that case, I would turn to another case that I cited in my brief, State v. Perez, which is a second district case, but that did concern an affidavit case. Police connected the defendant to his home, executed a valid search warrant at his home, and his vehicle at his home, and it wasn't until they discovered information about a storage unit in his vehicle that they returned on to the fact that perhaps there was additional evidence. I think they were looking for weapons in that case that they didn't
And I think
find
the
in the
difference
house.
between this case and Perez is you have this the similarity in some ways is the backdrop of the drug activity that preceded the search,
Yes,
right?
I would agree. Mhm.
However, in this case, we have this communication of a great sense of urgency of removal that which is within the safe and the storage unit, which you did not have in Perez.
Okay, I agree with that distinction for sure.
So
But
really what it comes down to then is whether that urgency that was communicated is enough in light of the fact that we are supposed to give a certain amount of deference to the decision in the issuance of the warrant based on the affidavit.
Understood. I would disagree that it's enough in this case because what we end up with in that situation is that urgency to go to any location then would be sufficient under the facts of this case. And I think that that's a problem because if we modify the language of the affidavit to say house, vehicle, not just storage unit, but any location that he's possibly connected with, then police would have enough in this case. And I think that that is not honoring the confines of probable cause, which requires a substantial basis. An urgency, is a subjective characterization of what was happening on that phone call. We're dealing with the four corners of the affidavit. We're not admitting that call into evidence for the trial court or the
I don't
magistrate
think
to
the
review.
urgency has been contested.
I'm sorry?
The urgency or the nature of the urgency, I don't think has been contested or anything like that.
It has not, but I guess what I'm trying to say to the court is that we're putting a lot of stock into that one word when there's nothing else in this case to really take the police from suspicion of potential additional activity in the drug activity in the storage unit to actual substantial basis amounting to probable cause. Like I said, Mr. Simpson could have directed his sister or his girlfriend to go to the house where a safe was located. Again, I keep coming back to this idea of bond money. He's in custody at the Hamilton County Justice Center. There is some urgency for them to go obtain something on his behalf. I'm not suggesting that the police omitted a detail in that regard, but we're putting a lot of stock in that urgency where there was no other evidence connecting drug activity to Mr. Simpson's storage unit. This isn't a case where he was surveilled going to and from that storage unit in between drug sales. Again,
Was that argued below that there was a reasonable explanation to support the urgency?
I don't believe that was argued. It's my offering to this court that it could be a benign characterization of what.
You're saying it's not a specific legal argument, you're just
Yes.
answering the hypothetical.
Yes, sorry, thank you.
Okay, understood.
And I stand firmly of the position that this case is analogous to Johnson and Perez, and it warrants reversal for the lack of probable cause. And I would further submit that good faith should not be applied in this case because we do have, in our view, a bare bones affidavit. The phone call, I understand, is a significant fact. It's a relevant fact, but I think it's relevant to suspicion. It doesn't get us over the hurdle of probable cause. It is not even a minimum amount of evidence that could toe the line of probable cause in this case. And there's plenty of case law that tells us that affidavits can't be based on mere speculation, generalized conclusions, which is basically what the officer did in this case, based on her training and experience and her understanding that drug traffickers commonly use places that they're associated with to store their drugs, the proceeds of drugs or other contraband. That's not enough. That's any drug trafficker that she's ever come in contact with. If she connects that person to a particular residence or place of association, then this affidavit would stand, and I don't think that the law
Yeah, I think
supports
we
that.
expressed that concern, I can't remember if it was Johnson or another case, about like, if you take that to its logical extreme, then that just means, I think you're a drug trafficker, I get to go search your house and your car and everything that's connected with you.
And I think that concern is present in this case, respectfully. I understand the court's concern about the phone call, but I don't think that that is enough to get us over the hump of probable cause. And why good faith would not apply in this case, because we're dealing with a bare bone affidavit based on speculation. If there's no further questions from this court, I'll reserve the remainder of my time for rebuttal,
Okay.
please.
And I'll reserve it past the 3.
Thank you.
Okay. Good morning,
morning, Your
Attorney
Honors.
Sauter. How are you?
I'm doing fine, Judge, thanks. May it please the court, opposing counsel. I would just note a couple of things. I'm going to be very, very brief. This was not a bare bones affidavit. I mean, there's clearly a detailed factual basis for indicating that the drugs were likely to be found in the storage unit. I think the urgency of the call, coupled with the fact that the caller, that the defendant in this case, was being a bit cagey about what was in
Well,
the
so
storage.
I just want to like drill down on that a little bit. Are you saying like the urgency is kind of the critical fact here? Like if he had said, hey, whenever you get a chance, can you go swing by the storage unit and see if my, safe is still there? Like, does that alter the probable cause calculus?
It does alter it. I don't know if it's a crucial part of it, Judge, but it's something that the trial court definitely relied on, saying that there was a sense of urgency about this. And I think if it had been some sort of a benign reason for calling his sister and his girlfriend, first of all, the timing of the call, it happened the same evening that he was arrested, so there's no doubt that there were, even if he hadn't expressed urgency, the timing indicates that there was some urgency. And I think that if he had been saying, I have bond money in the safe, there would be no reason not to express that. I think the fact that he was being kind of cagey about this whole thing indicates that there was an ulterior purpose, that there was something fishy about it, I'll put it that way. Yeah. And to the extent that Judge Bergeron talked about there are these in-between cases, the strength of the connection between the criminal activity and the place to be searched. I think, Judge, if this is one of those in-between cases, then I think certainly the fallback position for the state would be that, at the very least, this meets the good faith exception under Leon. As the Supreme Court's recently said, a minimum connection means only some modicum of evidence, however slight, that connects the criminal activity described in the affidavit to the item or the place searched. And I think we certainly have that
Do we need
here.
to get there, given the deference that we're afforded? It seems as if this is, usually when you're looking at the state versus the defendant,
Yeah.
and it's questionable, it goes towards the defendant. But it seems that this is not following that rule.
Yeah, exactly. and that's just, I would be remiss if I didn't argue Leon, which is the reason that I mentioned it. I know recently in State v. Johnson, it was a situation in which the good faith exception was not raised on appeal, and I just wanted to make sure that the state preserved that. And it is fully briefed in the written brief. So,
Because really, the issue before us is whether there was a substantial basis or whether it was speculative.
exactly,
And
Judge.
so, and of course, appellant saying there's not a nexus, it was speculative. So from your perspective, why was it not speculative?
Well, this is
Because it does appear to be a bit speculative because, yes, there was an urgency. Yes, the backdrop is the reason for the arrest and everything that was investigated and disclosed after the arrest.
Yes.
But nonetheless, how are we beyond it being speculative?
Two responses, Judge. First of all, it's what we're looking at is probable cause. So there's a certain amount of uncertainty in any of these cases, or in most of these cases anyway, and doesn't require a level. What we're looking at is probability here, Judge, and I don't think that.
Yeah, it's a
I don't think
substantial
it-
basis.
it
Is there a
doesn't-
substantial basis to
yeah.
conclude that probable cause exists?
Yeah.
So it doesn't really require for there to actually be probable cause, but there to be a substantial basis that probable cause exists.
And I would argue that in this case that's certainly that's certainly present. And I forget my second point now, but that would. Oh, and in light of the deference that this court has to give to the issuing magistrate, I think that we don't look at this. We don't look askance at the findings of the magistrate or the trial judge. We have the deference that we give the courts and the arresting officers would require an affirmance in this case, unless the court has.
But isn't it troubling? I do understand Attorney Nelson's argument with regard to it really, makes it sort of like a very open field of being able to search pretty much anything that is connected to the defendant, as opposed to searching things that are connected with contraband.
If it hadn't been for the phone call, Judge, I think that would be spot on. But in this case, it's the defendant's assertions, it's the defendant's behavior that specifically points to this storage unit. And I think under these circumstances, it's not. It wouldn't give rise to a situation in which the police could just conduct these generalized fishing expeditions. I'll put it that way.
Well, I guess, so I take it what you're saying is if if there hadn't been the phone call and someone just through the normal course of investigation discovered that he had the storage unit, that wouldn't suffice, the
Right.
affidavit would not suffice for probable cause. I guess my concern, though, is the statements in the affidavit that are not unlike statements that we've looked at in other contexts that say, well, I'm an officer, I've got a lot of experience in drug transactions, and I believe that there's probably stuff there because that's where drug dealers like to keep their contraband. And I think that's my concern is, like, at what level does that then become open season to anyone who engages in a drug transaction? Suddenly, like, you can search their house, their car, whatever.
Yeah. Oh, I understand the concern, Your Honor, but I think that if oftentimes we talk about these probable cause determinations as pieces of the puzzle. And I think one piece of the puzzle is the background of the officer to indicate that, this is often where drug dealers keep their stash. But I think we can't look at that in isolation, and I don't think the trial court did in this case. It looked at all the totality of the circumstances, including in the phone call, which pointed directly toward some sort of improper activity occurring at this storage unit, and I don't think the trial court got this wrong at all. There's nothing further. I'll rest on my brief. Thank you, Your Honors.
All right, thank you.
Your Honors, I don't have anything additional to add unless the court has any questions for me.
Thank you. Thank you for your arguments this morning. I really appreciate both of your arguments this morning. This is a really interesting case. We're going to take the matter under submission, issue a timely decision. Wish you both a wonderful afternoon. And that concludes arguments for this morning. Thank you.